One of the things that we were going to talk about today is ADR, alternative dispute resolution.
Yes.
And this is really the term that's given to it by the courts, and they call it they were calling it alternative dispute resolution because they wanted us to consider, as lawyers and anybody in a dispute, alternative methods, i.e. don't come to litigation. Let's look at what other methods could be used to find a solution, isn't it?
Yeah, you've heard us today setting out and explaining why the court system takes a long time, is expensive, and for the longest time since since all of these reforms actually go back to the late 90s, but since the introduction of the civil procedure rules in around 1999, there's been a big push from the judiciary, the overriding objective of the civil procedure rules, the white book that we are subject to, which is our sort of Bible, encourages parties to resolve disputes, yes, judicially, but also to act cost effectively. And one of the methods that they one of the methods they've tried to achieve that goal has been to push and encourage parties to engage in ADR. Now, for the most part, that form of alternative dispute resolution, what lawyers hear when somebody says ADR is mediation. And that's the most common form of ADR that is used. But my understanding is, and you know more about this than me, but there's moves to make mediation compulsory. But before we get on to that, you need to probably explain what mediation is.
Okay, so mediation being where you force the parties to come together, or voluntarily come together, I should say, rather than forcing them, and you appoint a mediator who's an independent third party who runs between the parties trying to get a deal. They're not binding, so you don't have to come to an agreement in them. You can have the advantage to them is you can do all sorts of weird and wonderful deals that isn't possible because a court will often say, yes, you're right, no, you're wrong, and will award accordingly, whereas you can have more constructive agreements come from a mediation. So you can have weird and wonderfuls, which
apologies, a court can't order apologies, a court can't order, you go and finish the work on my bungalow.
It can't award, unless there's a trust point, it can't necessarily award that a certain asset be transferred in payment of something.
Or a confidentiality
agreement. Yeah,
I mean, public court proceedings are always public in most circumstances.
Absolutely. So it keeps it out of the public domain, and it can shortcut and it can quicken a resolution to a problem.
In a mediation, there is normally a mediator. And what does a mediator do in a mediation?
Their role's purely to try and get the parties to talk to see if they can reach a settlement. They are not interested particularly in the merits of the case.
Who's going to win or lose?
Who's going to win or lose?
They sort of engage in shuttle diplomacy typically. I mean, you will often find your traditional mediation, you go to a barrister's chambers or to a hotel. You sit in one room, your opponent's with your clients, your opponent sits in the other room with their clients, and the mediator kind of walks between the two rooms, listening to what the other parties have got to say and trying to come up with a deal, really. That's my experience.
That's pretty much it. I mean, sometimes you have round table discussions with everybody in the room, but they don't.
I'm not the keenest on them, if I'm being entirely honest.
A pure commercial discussion and a commercial dispute where there's no personal feelings involved, then they can work quite well.
Yeah, and I think, and again, I mean, I went into practice in 2001, so virtually all my career has been in the era of both the civil procedure rules, often they used to be called the Wolf reforms, but all of my practice has been under that regime and has had mediations involved in it, and they have changed a little bit. I mean, I think like anything, we sort of try to import them whole scale from America in the first instance, and the ones that I went to in the early 2000s, virtually no one would make an offer before 6 o'clock. You're not into any of that, having to be typing a settlement agreement at 1 a.m, which was how it used to be. But there are some changes as well. You've dealt with a number of remote mediations.
Yeah, certainly through the COVID period, it was very difficult to get people together, and that inspired more use of things like Teams and Zoom, and they can be very good. Sometimes the problem you have is if parties are either acting in person or if everybody is separate and not with their lawyer, sometimes getting the focus there can be difficult. Whereas what we've adopted occasionally when we have to do these, if we can't do them in person, is to have the lawyers and their clients sat together, and then the mediator, and then the three parties remote. And the advantage to that is, one, you can help your clients along a lot more. Two, nobody's sat at home, so they're doing their normal day job, and you can really get them to focus.
Yeah.
And drill down into those